clearance de derechos en la industria audiovisual y musical.
Clearance of rights clearance in the AV and musical industry. Gerardo Muñoz de Cote, VP IP and Content for FILLIP, Mexico. Deyanirr Solorio, Deputy Director of Business Affairs, OCESA, Mexico. Juan Camilo Riva, Lead IP and Media Counsel, FILLIP Labs, Inc., Spain. Moderator, María Soledad Álvarez, Head of Álvarez and Associates, Argentina. Good afternoon, everyone. A friend of mine said to me some time ago that in the last talk of the day, you can really see who your friends are. And I see a lot of friends who've stayed for this last session. So thank you very much, and thank you to this great panel I had the pleasure of meeting in the past few days as we were putting together this panel focused on clearance, focused on musical work and AV work. And I am happy this is the last one, because if they really did the homework. Let us talk about everything, not only copyright, but the issue proposed to us in different systems, continental copyright, and how can we know about all this so we can analyze the whole thing, take a look at this risk that we have to take or not take, and we have to review it as we look at clearance. And it's not only copyrights, but who are the authors, the owners, and the type of business we are doing, if we are going to talk about things related to brand, to patents, and image rights, and filing as well. And we will talk about all that today. But first things first, let us introduce the people with us today. So let's see. Okay, not so fast. Let us go on. Let us move on with our first speaker. Juan Camilo is an attorney. He is from Colombia. He graduated from the Pontificia Universidad Javeriana of Colombia. He has a specialty in economics and intellectual property, a master's in digital business. He lives in Spain now. He was an attorney for Procter & Gamble. So for some time, up until some time ago, he was on the other side of the fence. He is the head of intellectual property and legal marketing for FILLIP Labs. And with this short video, let us take a look at what he does at FILLIP Labs. So, you cannot say what you do is not fun, because FILLIP Labs is a head firm in live performances. Our next speaker also has a lot of fun. Her name is Deyanirr Solorio. She is an attorney specialized in entertainment law, intellectual property, and transactional law. She is a graduate from USC Gould School of Law, South of California. She is the head of business affairs at OCESA, a leading live entertainment company in Mexico and Colombia.
In OCESA.
At OCESA, we take the fan experience to the next level, putting together unforgettable events with the most vibrant shows in the national and international scene. Our creativity and consistency has really made us the biggest and most important platform for live events in Mexico and LATAM, and we are the top 3 in the world. We are one of the top 3 in the world. We are part of a Live Nation, a leader in the industry. We have a live entertainment ecosystem that is high quality and very professional. We produce thousands of concerts for all musical genres, more than 20 festivals, theater plays, family events, gastronomy events, and sports events. Being committed with delivering the highest standards, we are the main choice of brands that see in music and entertainment a way to connect with millions of spectators. Our live entertainment ecosystem, focusing on mass events, focused on fans and our commercial partners. We have a we have a big real estate portfolio, theaters, auditoriums, arenas, and concert stadiums. Large spaces to celebrate the biggest festivals. We live to entertain you, OCESA.
Por último,
And lastly, our panelist, Mr. Gerardo Muñoz de Cote. He is an attorney at law, graduated from the Ibero-American University. He has a certification from Red Vox Academy. He has a clearance right for film and TV, certification from the Palmer Institute in Germany. He also has a certification in AI from Berkeley, California. This is a business strategy applied to AI. He is currently the VP of IP. He used to be the IP head in Mexico. Before that, he had a position on television. So, the history and experience of our panelists speaks for itself, and they will explain what clearance is, coming from each of their industries. What is it that we do? Hello, everyone. I am happy to be here. Thank you very much, ASIPI, for having me. And like as I was saying, because we are the last panel, I think what we all four agree on is that the focus has to be very practical, and especially having a vision that is very realistic and very current, considering the challenges that we do today. So for FILLIP, what we do, just for those of you who haven't seen it, we started about a year and a half ago. We are a startup. What we try to do is to get IP assets in the entertainment and sports world. So what we do is to get these rights, these intellectual properties, and transform them into different formats so we can use them in different ways and trade them in different ways so we can get a lot more value from that IP. We have an internal motto, and the way we say it is unlocking IP potential. So this is what we want to do, unlock IP potential. But just like they said it in the previous panel, here at FILLIP, we believe that IP is ever more relevant in different markets, and I am sure you've seen, ever since COVID, global funds move towards musical catalogs. BlackRock and some other very strong funds started to take a look at IP assets. So this is a little bit of what we're doing. Just to answer the question, to me, clearance are 3 steps that work together. Number 1 is identifying rights, the rights you need so you can put together whatever project you're thinking about and pinpoint them properly, not only in the present, but also looking into what the project may need in the future, and maybe go right away into securing those rights. 2, make sure that you are meeting all the legal expectations for IP owners as well as for regulations out there. Oftentimes you get the rights, and when you carry out the project, there is a bit of a conflict situation or a contingency that may come up because of external issues external to the IP owner based on the way you exploit those rights. To me, it's those two things. Well, like you've seen it, like you just saw, we put together different events when it comes to concerts. From the clearance point of view, a little bit of the analysis is take a look at who we are negotiating with, big artists who are usually being represented by agencies. It is usually easier. It's difficult with emerging artists. We will never negotiate directly with the artist, but their manager has to really be their manager. And those are the hardest contracts. Emerging artists, sometimes we have to negotiate with the family, which can be a little bit complicated. So we do put together large shows. We did it this year with Luis Miguel. We also had it with Taylor Swift. These have been simpler contracts because they have a legal team next to them. Their attorney is a person who's had 35 years worth of experience, and this makes it simpler. And also, we try to identify things, and we try to do business with Cirque du Soleil, and we feel like we're negotiating with the right people, and these are relationships of trust. When someone new comes to promote a new project, this is when we have to really look harder and make sure that what they are selling is what they have, and how this relationship changes based on the type of event. For a concert, we know they fly in, they'll be here for 1 or 2 dates, versus a theater play, they'll be there for 7 or 8 months, and we have to look into everything that can happen during that play. So we try to set a scale for these risks and measure them, and then have everything we need so we can look into these risks. You cannot really control everything, but at least we try to make the business move forward. And as we move forward, we can hopefully look into these contingencies, but we cannot be so strict where you just claim saying, I know that I will make sure that nothing happens. This is not realistic. And as the internal counsel, you can never really assure that the event will have no issues. And and we have to talk to the commercial area and say, hey, this or that can happen, whatever, especially a concert that has a lot of external factors moving around. Well, great. Thank you very much. Thank you for being in this last session. It is very nice that you are all here, and it never hurts to talk about these issues. And I hope you don't fall asleep. This is a very interesting talk. And so I can answer a little bit of what clearance is. Let me just talk a little bit about the company. The video is not enough, of course. I think I guess we could be called competitors against Deyanirr and OCESA, but we're not there yet. We put together events, but maybe not really. We put together tribute or candlelight concerts. Maybe in Argentina, Colombia, you've seen this, or you probably got an ad on YouTube, asking you to come. The candlelight concerts, those are put together by Fever, and I will focus more on those type of events for this panel because this is the AV and musical industry, and this is what we want to talk about. I will not go deeper into immersive experiences, Netflix, Stranger Things, that was there in the Fever video. Let us just focus more on the candlelight experience. So candlelight concert is a small concert at a nice venue, lit by hundreds of candles, and this is a tribute concert. We have a candlelight original. We have the actual artist there, but these are smaller events. not 25,000, 30, some 40, 50, 60,000 people. A Taylor Swift concert, I mean, we can only dream of having Taylor Swift, but what we can do is to redo Taylor Swift's music and maybe a quartet, a string quartet, or piano, and do Taylor Swift covers in candlelight and take it to a few cities. The U.S. is a great market, is a big market. We're breaking into LATAM, like I said, Brazil, Argentina, Chile, Mexico is pretty big on that. We will break into Colombia next year. We want to make it to Uruguay, Panama next year because the company is growing. So in the next 5 years after the pandemic, we hope to be a big player in entertainment, but obviously diversifying entertainment, different to what was done before, not huge festivals, huge concerts, but actually delivered in a smaller format. So I think this will be a very good conversation between the three of us and with Soledad and her comments, and hopefully when we go into the questions, hopefully we can have a good debate because the way you offer entertainment is different now. So clearance. So I do not belabor on this. Clearance is what you do so you can put together an event. But to me, in my company, that's actually a startup that has been around for not too long, is about implementing a compliance and due diligence culture because a company wanting to grow, company is fine, and we'll set up a Vivaldi concert. Vivaldi is pretty popular at a clearance level, almost nothing. But what if you want Taylor Swift? That's a whole different story. So if you start to have Taylor Swift concerts in more than 20 cities without letting the IP department know because we're the last ones in the hall, you can have an issue. So to me, clearance starts from that, from timely communication and having a compliance culture. So now, Juan, when uh, when you negotiate with Taylor Swift's or Luis Miguel's attorneys, isn't it easier for Deyanirr to do that versus you and trying to work around IP issues and thinking about how to get rights? Because here, for her, scale matters. Uh, on the musical side, so if I screw up, I can have issues, but when you're talking about AV and you have it on different platforms and different portals, I mean, how do you uh, reel it back? The industry really changes that risk analysis approach, and how do you do that risk analysis approach on these type of events? This is actually a pretty interesting question. At Philippe, we've gone through a series of IPs, of all flavors, all kinds of situations when it comes to IP. We had the Chavo del Ocho, Frida Kahlo, Maradona, Pelé, wrestling, a Kings League. We ended up investing in that. Lucha Libre, we're actually doing pretty good with a Mexican entity. Now, about artists, and just like she said, we've talked to two top tier Mexican artists, and just back to what you're saying, Soledad, when it comes to clearance, and someone said it a moment ago in the panel. Oftentimes, the analysis gets too technical, and then the commercial side of it doesn't want to know all that. The project will happen no matter what. You just have to mitigate the risks and list them specifically. Back in my time with Netflix, I was there for 5 years, and we saw a lot of projects all the way from Salvador Dali's clearance for you know, uh, the heist show and the mask, and then also um, using the face of people from the private sector, not public faces, but actually private identities, and using that in some shows. But it's all about what kind of decision to make when it comes to very sensitive content, and maybe we had to suggest to the creative and content area to adjust a little bit of the storytelling. And let me just wrap up by talking about this case. I remember it clearly from Brazil. This was about a series called Porta dos Fundos, a Brazilian producer. They put together this Christmas special. It was a satire on the Catholic Church, and uh, a council of the church presented presented a request in court so they take it out of the platform and not be streamed. Ultimately, the company responded saying this was a freedom of speech situation, and the ruling was in Netflix's favor. The Supreme Court of Brazil ruled that this was a freedom of speech situation, but still, there were thousands of Netflix subscribers that, stopped using Netflix because they were upset because they were mocking their religion. So, and maybe the risk analysis is good because you were able to analyze the risk, but this is part of the risk context, not only at the legal level, but also at the PR level. Let me just take that same question. So, risk and how do you monetize it? Who deals with it? How do you work around it? Let me go back to a little bit of what I was saying before. It depends on where or when you come on board. If you're an in-house entertainment vendor and then the idea is ready and then they include you, the risk is that there's always risk because the clearance was not done properly. So the challenge lies in identifying the risk and tell explain to commercial people some of the things that are red flags. So my team is always informed and trying to review the risk before going into the business, not doing something and then afterwards saying, "Hey, we have a fire," in a company like my company or the company I work for. I wish it was my company. I work for the company. So the IP department was created 2.5 years ago, and they asked me, "Juan, can you set it up? What kind of risks do you see out there?" I said, "Look, there's a lot of risk out there, and it was difficult for us to work proactively because there were a lot of risks that we identified, and because we weren't working proactively. And it wasn't until now that people understand that you have to raise your hand. And how do you do risk analysis? You have to make sure that you review anything you need to review so you can deploy your project. So for an in-house counsel, people have to hear you. You have to raise your hand, talk about the possible issues, and then say, "Hey, watch out! This or that can happen, or you're not going to be able to put together your project." So it's interesting what you're saying. It's just like the character Mr. Barriga when Chavo del Ocho, the series. It's like, here comes legal. They're going to poach a hole in my project or whatever. They either see you that way or see you as an ally. Most definitely, and sorry for jumping in, but here we have to think about, your the whole idea or the way they portray in-house counsel is that we are blockers or party poopers, but we're usually we want to be enablers. If this is what the company brought, if this is a project they brought in, help them to see it to fruition. And this is way better than, than dealing with other things, like privacy attorneys and other people, those who deal with privacy and data protection. It's all about following the standard and not being flexible about it just to avoid sanctions or fines. So you want to be enablers.
Well, my experience, I came from a firm, and then, yes, well, you're used to providing an analysis that this could happen, the losses, this and that, and yes, you have to find allies in the business. If you're an event promoter, the promoters are the ones that negotiate directly all the deals with the artists. Well, we are there until the commercial part is closed. When you define how many dates, how when they're going to get paid, and then do the contract, the artist wants the money. So we're talking about large figures that we're not going to give them money without a contract, and that's where everything speeds up. Everything has to happen right away. If you don't answer tomorrow, the artist will go with somebody else. So it's an industry with a lot of ego. But yes, out of my first projects, we negotiated a contract for a musical with circus for Juan Gabriel. That was 2 years ago, and we had to negotiate with an American company that already had the license to carry out the show worldwide directly with the person who was representing the inheritors of Juan Gabriel. That was my first 3 months in the company, and this lawyer didn't want to share with us the document he had signed with AIR due to confidentiality issues. Yes, we did have in the contract all the guarantees and representations that they had sufficient rights. Then in the event of anything, well, everything would be cleared for very large amounts, but they didn't want to show us the documents, so I was along the line that, well, I have to look at all the documents. I need to basically have them all in my hands in order to have the certainty. I approached the general counsel and I said, well, he didn't want to give. They don't want to give me the document because of confidentiality. And he said, "You're gonna sign the contract. You feel comfortable signing without seeing the document?" I said, "Of course not, but it was change the vision of the legal responsibility of this project." Well, of course, there's a lot of investment, and he said, "Do what you have to do. If you have to go and see it, or through a video call, if they don't want to share by mail the contract, go over there and get a copy." Eventually, he showed it. I could take I was able to take photographs, but yes, this vision. Well, you need to have the document and see it, and it's your responsibility to sign it. And I believe in the whole matter now. The decision on the side of the company, and the risk is mine, and you have to become a non-controlling lawyer, a more flexible lawyer, and the show must go on. So do as much as possible. But there was another case with Anastasia, a musical. Anastasia is based, obviously, in historical facts in the history of the Romanov family. But there was a script written back in the 1948. Then you have the Disney movie in 1997. And there was also a movie in 1965 in Broadway. And the musical was released in 2016. And the heirs of Marcel Moret, who had written the script, sued the company, the Broadway company, saying that there were certain aspects of the story that were based in the script from 1948. The defense of the musical people said, well, it's not based on historical fact. And the judge progressed in the U.S. We, back in 2019, well, from 2017, we started negotiating the project. Everything was agreed upon. It was, in August 2019, they were going to have the premiere, and we found out 6 months before that the proceedings were ongoing, and there was a motion in the U.S. to call to trial, and the company had to grind to a halt, and they said, we're not going to do it. We won't have the license to present on a stage in Mexico. Why? Because definitely there was the possibility of infringement. We didn't have sufficient rights to be able to have the play in Mexico. And if that infringement prospered, it would be a decision against at least 40%, which is the business is no longer profitable. In our case, the profit margin is almost always, well, the artist takes about 80, 85, 90%. And as promoter, we get this 10% profit margin. So thinking if this goes forward, 40% is not economically viable. So we decided not to do it. We had to look for another play. And we ended up with a Chicago musical. We put Anastasia on hold. And now at the end, there was no trial. There was an out-of-court settlement, and the heirs were right that there was copy-paste of some scenes, and we talked to the Anastasia legal team, and we understood the situation they were in, and we were not going to acquire the rights for the time being. And the pandemic was over, and the play was launched in 2023, and the relationship continued, but also communicate this is a stopper that we cannot, and it's evident that if we present it, the heirs will sue us and therefore sue you. And it's not just the payment plus royalties, but we're talking about 40% of the possible profits. And this connects us with this. Who are we negotiating with? It's better to negotiate with the author, with the agent. Is it a bigger problem to negotiate with heirs? Is it riskier with one of them, with all of them? Yes, and I just emphasizing on the point that we were mentioning before. It's happened to me quite often that you already have an approach to a right owner, and then you realize that the wrong area did the reach out. That's why it's so important that whoever makes the first approach is the legal team or the commercial team slash legal team. It be done with a correct right owner. It happened with Frida Kahlo a while ago. That we wanted to do a project, and we were talking to Panamanian company that are based here, the Frida Kahlo Corporation, that have an immense catalog, a brand catalog, but they don't have the rights regarding many of the works of the cultural stock of Frida Kahlo and Diego Rivera. So we had to redirect, go to Bank of Mexico or the Maras, which are the family that had legitimacy. Well, we're talking about this, that it may have happened to many of us here. But yes, the question of who we negotiate with is critical. We mentioned a while ago as well during the lunch when we were discussing that often it's easier to negotiate with the heirs. In many other occasions, it's way more difficult depending on what the project is for, what you want to do with the rights. Perhaps there's more flexibility from the heirs to carry out some sort of transformation or variation regarding the IP asset per se, and when it's the original right owner, there's this the author is bent on doing something very specifically with the work. Who do we negotiate with? A lot of people actually. We've been discussing this with a panel of colleagues a while ago. Collective bargaining, for example, in clearance in the musical or AV industry are essential. Collective bargaining is a facilitator. To do over 1,000 concerts for the same artist in a year, and have a catalog. The concerts we have around the world is thousands. How do I have collective bargaining? I mean, depends. Go to Argentina. Go to Argentina. Negotiating with them is in the complex. And what do you want? You want the audience? I mean, I'm bringing volume. I understand that there's a law that says how much you can collect, but informality is prevalent there. But I'm not defending this. But you have to approach them, because when you're having 200 concerts, and from your P&L they're pulling out a great percentage, you have to know how to negotiate in order to be able to have a win-win relationship where I can have my concerts, you charge what's necessary. Obviously, what we want with a collective bargaining entity said all the artists that are being are getting a tribute also get royalties, but there has to be a margin, a flexibility. Why 0.8% is in the U.S. for a concert? We get to the mechanism and I say I'll report everything, I'll calculate all the tickets I sold, and you lower the fee a little bit. And what they're doing right now is they're lower their middleman commission, but that makes easy for all of us. How do we do it in the U.S. for them to be able to bill on time, and so everybody is good standing at that moment? So negotiations there, actors. So what happens as well? They told me 2 years ago, look, Warner is turning 100 years old, and Warner wants to have a candlelight, and a candlelight for Warner means that we have to see the soundtracks of the movies and the series produced by Warner Brothers. Okay, we're negotiating with Warner Brothers company. What does Warner Brothers says? We'll give you the name and the logo, but who gives you the music? So when we're setting up the concert, we have all the artists in each one of the 100 cities where we're going to do that, the 100 concerts. Everything's ready, but there's no contract signed with Warner. When the contract comes up, well, the music is not there. They don't have it. Who have it? The publisher is Howard Shore. Who did the soundtrack for? Oh, Mr. Howard Shore. And what happens with a composer like Howard Shore, that if you're going to modify his music, he has to check the score note by note. And if he doesn't like something, he's going to ask for a change, and it might take weeks. So what happens with the concerts? They'll get delayed. Who do you negotiate with? What I was saying, the most important thing is to understand who's the adequate right holder to do what you want to do. And in your projects, in your experience, bring in the heirs and the authors for the script. Does it make it easier? Does it make it more complicated when you have a product that is half ready? And they say, I don't like this too much. Great question, because when you get the IP owner, you bring him into the project, they bring the banner, the seal, almost the authorization. that is approved by that artist. It's happening with TV series, for example, very famous ones like Luis Miguel, the series, and many others. That when you have an approval of the history of the artist regarding the storytelling, memorabilia, it facilitates perhaps access to material that only he has, but at the same time, there's a creative control that is sacrificed because the artist, the creator, will say, "Yes, tell my whole story, but don't mention this." It happened, for example, with a Colombian producer in the Vicente Fernandez series. So I believe that we have to put on the scale the pros and cons, and I believe that depending on the creative scope you're looking for, that's where you precisely have to carry out the analysis to see whether the question of what's worthwhile, say, ask for permission or say you're sorry. You have to find the legal guidelines to be able to develop a product without the authorization. Many of the lawyers sometimes are afraid and say, no, we have to request all the clearances and approvals. And often that's useful, especially in countries like the US, where errors and omissions insurance will not be issued if you don't have the full due diligence with the clearance report, the title report of the brand, and so on and so forth. But sometimes it's more like a requirement. It's useful for the commercial area. Mention, is it better to say you're sorry than ask for permission? Sometimes the easy question would be yes. But sometimes we're apologizing here as well in the sense internally. I believe that yes, no, we have to become partners. It's important that the commercial area tells us what they're going to do, and not that first ask for forgiveness internally and then externally. I think there has to be a lot of synergy, and that they don't see you like the person who's going to say no, because it will always be more difficult to fix something once it's out, and depending on the type of business. And I say here also, this change of culture is taking place, and in spite of being a large company that has been for over 30 years in Mexico, now we have this area only focused, which is the area I lead, which is called Business Fair. We see all the relations with the artists and the licenses, and of course we also have a legal team that is responsible for the permits, migration issues for the artists, the labor aspects, the whole area with the sponsors, the commercial area. So right now, it's getting a stronger focus because we're an appealing company. If we do something wrong, immediately they're going to go after us. But going back to collective bargaining societies, well, we have a good relation because we are their best clients. They keep a percentage of the box office. And this is right. We have to pay. We're going to pay it, but due to the amount of events, we have preferential rate. So we had to negotiate well with this whole side of innovation with the pandemic. Well, the company had to carry out events somehow. We had 18 months that we were at a standstill. We had to let go over 50% of our staff. But while that happened, well, what type of events can we have? There were many events only for streaming where we did charge. The Collective Negotiation Society raised their hand. This is no longer public communication, and we believe that we have to negotiate something for the transmission of events. And eventually, well, we got to an agreement. Well, some festivals are broadcast, and we already have, depending on the amount of hours of transmission and the amount of platforms, that will be the rate we have agreed. And also, well, it's meant a challenge of what other types of rights do we have when we're talking about streaming and the participation of the brands. And I believe, I say, still, we want to be there live in the event, but we have this other platform that the brands like a lot. We do not charge additional tickets for streaming. And I think that that's where we were able to reach a good agreement in saying, I'm only charging for the event and there's something additional I'm doing. The story would be different if we would also charge for the rights for the streaming user, but that's the way the industry has been changing. Juan, in the tributes, what happens is that perhaps the heirs or relatives do not give you the rights, but they do not bring down they don't eliminate the tribute. You're in a gray area because there's like an interest. I'm not saying yes, but I'm not saying no, because the worst thing that could happen is ostracism, and you're doing the candlelight. I love it. That's a good slogan. I believe I never have had a case with heirs, perhaps with foundations created post-mortem. The case we were discussing precisely of Avicii Timberlake. He died a few years back. His electronic in-house music, the candlelight team had the brilliant idea of having a candlelight of Avicii without telling us. And I was interviewed for Avicii. It started in London and Liverpool. We have 3 concerts already. The 5th one was in Berlin. The 6th one was in Stockholm, where he's from. And the one in Stockholm was going to be on his birthday. So what happened here? The Avicii tribute the registered trademark. Then the music, was there clearance? No. Then what happened? The foundation that he made with his family to devote his music to aid for people with mental conditions and drug abuse or substance abuse. And they knocked on our door and you were saying, hey, what are you guys doing? What are you guys doing? So we had to cancel the upcoming concerts. The brilliant idea of doing this in Stockholm on his birthday. They didn't like the idea at all. But with theirs, I haven't had problems, but rather with foundations, because they have a clear purpose. If there's no clear purpose, probably the heir will probably facilitate the exploitation of the work because they want to monetize. And another example, perhaps no longer with the heir, but with live people, I like to talk about Taylor Swift. You still do Taylor Swift concerts, but because of her, I didn't sleep for about 2 months. Why? A tribute to Taylor Swift, marvelous, in New York. And they started advertising, and the advertising they want to put in one of those ships that take you from New York to the Statue of Liberty. Taylor Swift, like you never seen her, candlelight, and an artificially generated face, likeness violation, brand as well, and the music. We were negotiating. It's a giant. And Taylor Swift gave like to a publication for candlelight on her publication because. And there's 2 options. She likes what we're doing and she's supporting us, or we're in her radar. And she does not play around. I didn't stay for 2 months after Christmas. I relaxed, nothing happened. We continue with the Taylor Swift tribute. What happens after clearance? Is there life after clearance? Can we sleep? We don't sleep again. Yes, I'm saying, after the Taylor Swift I think you speak to her manager, and what is the manager going to say? Actually, total. The clearance side, I believe it's a need that we have the presumption that it will be a tedious process, and often it's happening that it's a very easy process and an incredible collaboration with right holders. And what risks do we have after? Like we said at the beginning, often the project has not well identified what is the scope, and the commercial is easy for the commercial area to do something else related to that original project, and that's where you smash your fingers in the door because you didn't have perhaps the initial process didn't have the sufficient scope and the acquisition of the rights. And there's always that flexibility to start adapting and expand the project more. And I believe that that's where we have to be very close to the IP owners to keep them updated. They often, it's useful for them to see the information that you can provide to them, especially today with digital aspect metrics viewing. There are more tools so that you can offer this as part of the product the SEO has. I'm going to give you this. What are you going to give me? Not only money, I'll give you these references, these metrics, and for them it's often incredible because they constantly redirect other businesses that are not part of the session that they're sharing with you. Okay. And in that part of the contracts, we have to be clear internally what rights did we acquire and what are we allowed and not allowed to do. With sponsors, it happens to us often in the clauses with the contracts of the artist. It says that the sponsor may refer to the event, but they cannot do direct endorsement with the artist. So it's also we also have to send very brief mails to the internal areas. We negotiated the rights, and we can do merge. We can sell all these categories. We can have the publication, the social networks. We're allowed to do it for this use. The artist sends us their files, and they say you can only use this photograph for your posters. And this culture, no, because the photograph of the artist is in the website on their own website, doesn't mean we can download it and do the ad campaign. So you have to be very cautious. Of course, any artist, if you use a photograph that is not authorized by them, in spite of the fact that you're already paying them for their services, well, we could also have issues like internal consequences, and you don't want to have an angry artist. It's very funny as well that we will work with people that are unique. We were selling other services, like for example, well, I get another vendor to get the service, but in this case, we are the ones who want to have that artist who is unique, and we're always a little bit at their mercy, and we also depend on the leverage that this artist has. These cases are very special and very well-known artists. You have to be cautious. You have to advertise at these times in these platforms. Don't mention anything else. And I believe that with the sponsors, likewise, they know they're buying the right to have a presence, but you have to be clear with the boundaries, because we're an intermediate point, and where we have to we will be the ones facing the consequences. Another case that happens to us sometimes is when bands split up, and well, who keeps the brand? So almost always, well, these are conflicts, internal conflicts. There's a lot of ego and payback and revenge, and we've had in events and festivals that they sue us for non-authorized use, for using the name of the band, and then we start doing a little research, and the same band members are mad, and they sue us, and to do the advertising, we have to bring down the festival posters or banners, and you say, well, I'm sorry, I cannot use your band name until you fix your internal conflicts, but if you want to use your own personal name as a solo artist, we can do it, but we cannot risk several concerts with other groups because of a conflict in one group. Well, now we get to artificial intelligence and clearance. We were worried throughout the whole session regarding how do we protect what happens, how do we see intellectual property of an authors when we promote the services, but you're also in a situation where there are times where you should be able to use a voice and image. It's like Santa Claus comes with a lot of gifts. Is it an opportunity, a challenge? How do you see it? What is the future of entertainment? How do you see it? And I would like to share with you.
¿Cuál es el futuro?
We used to go Do you go see their recitals or the Avatar? This video, I don't know if you've heard, but it's generating an incredible phenomenon in London. It's a recreation of the ABBA group from Sweden, and this entity that has the ABBA rights, and I was talking about that with the panel during lunch, as well as other groups like House Mafia, Cyndi Lauper, Keys recently. What they're doing is incredible because this Pop House Entertainment, a Swedish company, is taking different buckets of intellectual property of the artist, practically three, which are the whole branding, the musical catalog, and the likeness, the let's say the rights to use the image of the artist, and they mix everything, and they have these incredible concerts with digital avatars. By the way, they're not holograms. This is different technology, different from holograms. And just to give you the reference, they generate 2 million revenue per week. That's 100 million pounds sterling a year. So, and the experience is practically as if you were if you were seeing the original group, because if the artist is still alive, you set a series of sensors so you can identify the avatar with the same body and facial movements, and obviously the voice is artificial intelligence makes it almost perfect. And there's some that are not truly in favor of this. Well, I will think that, well, we want to be there, we want to be in the concert and see the artist, in spite of the fact that sometimes we know that it will not sound the same as in the record, but it doesn't matter, we want to see them. I don't know, right now it's happened. There's been some criticisms to some artists for reggaeton and urban music, and they say, well, they don't sing, it's the tracks, the voice sounds awful. But in the market, people keep buying the tickets and they want to be in the concert, surrounded by other fans. And I mean, we continue betting for live entertainment, and I think the company plays a lot with nostalgia and emotions. Perhaps this artist will never come up again. You gotta be there. You're gonna miss the opportunity, and people are also willing to buy the tickets. But the reality is, and artists as well also realize this, that they are charging more and more. Uh, they're seeing the way to see whether tickets run out on 1 or 2 days, and the resale channels are the ones that sometimes generate 200, 300% more than the cost. The artists are raising their prices, and still there's a lot of demand. Well, the biggest one has been 65,000 attendance. Next year, Shakira broke the record. She'll be in Mexico 7 concerts. But thinking about Mexico City, we have over 20 million people living there. So, in this case, ironically, we need about 350,000 fans, which proportionally is not that much. So yes, well, we also have to receive the part of I want to be there, but I can't get a ticket, and the virtual queue in Ticketmaster. We've all had nightmares there. What I'm trying to explain is that there's a lot of demand. I mean, there's a lot of us trying to go to the same event, and I believe that that's what the company continues to play with to generate this emotion that you have to be there. You're gonna miss it, right? So I also mentioned streaming, but what we've seen is that people want to continue buying tickets and want to continue going. It seems to me that these artificial intelligence matters. Well, if the artist is no longer there and the ones that have the rights are willing, well, it's a great opportunity in order to have this nostalgia and relive something or remember those good times.
I think it is wise to leave some time for Q&A. If not, then, well, we can close this AI part of it. Uh, Number one, because I am a reading nerd. If you've read Isaac Asimov from back in the 50s, he was already talking about robotics. And what he was saying is a little bit scary. AI, I know we cannot, you know, we cannot run away from it, but like Uncle Sam says, it's a buyer's market. It's whatever demand wants. And I am sure the industry will continue to look into exploit works or create new work and let us find out and see what companies can do it. What kind of policies will they put together? Legislation has to move faster, I think. It has always been an issue with digitization. When we started to see influence marketing, there was no legislation for influence marketing. Now we're getting there, but sometimes we get there too late. So I would like to encourage everyone, whether you're in-house or whatever you're doing, really focus on this. And like my colleague said, it is something worth mentioning. That is why we brought it up. It is unstoppable. It is happening. We have to learn more about AI, like Yayo. Great example. And I think that's it. We can go on to questions. So, anyone, questions? Right. So, I thought the microphone was going somewhere else. Now that you put up ABBA, I was going to tear up, and I thought about the Beatles and hoping to maybe get a concert. As long as there's authorization from the artist, I think that's fine. I think that ABBA was happy about the whole thing, and like you were saying, Gerardo, it's a great success. There's still a lot for us to do without AI. I am a huge fan of OCESA, so here's my question. I know that for candlelight concerts, it's easier to have a collective partnership effort for a tribute concert, and it's easy for you. But for OCESA, however, I do not know if it happens in Mexico, but in Guatemala, every time there's a play, a theater play, or a movie screening, even with cable operators, I mean the unions pull their teeth out, and they want to take a chunk out of you. And in the case of a musical play or a theater play, there are copyrights issues for things that are part of the play. So some of these management organizations have nothing to do there. So how do you deal with the whole management organizations issues if they have those contingencies? And to Gerardo, you talked about Chavo del Ocho, the show. I think we have to thank your company that Chavo del Ocho is already uh, getting streamed, and we thank you very much for that. If you're partially responsible for that, that's great. It is definitely something recognized in the legislation, and I think the company has been dealing with that. If it's something we have to do, we will do it. And the company has been working with these situations, and we understand it. It's part of the industry. We try to have a very good relationship with them. We have agreements with every single one of them. And we're also trying to reinvent ourselves and pay whatever it is we need to pay. We have had some differences in some things regarding what is the right cost for a license. We've negotiated for a streaming service. We had to sit down and have several conversations and explain that we weren't really making any additional money for it. It wasn't a one-way ticket for streaming, and we had to explain that we were only getting money from the ticket sales and not from the streaming service. So explaining to them how all of that worked was complicated, but this is something we have to learn how to live with. And internally, this is budgeted in every single offer that is presented to an artist. And there's a margin for it. So, right, for theater plays, and for some shows, legislation says you pay the owner or through an organization. So there's also an approach when the owner tells us that they will get the share, they will get the profits. They give us a document. We avoid a union from getting involved, but we make sure that we're paying the right owner. Lately, some international artists tell us, pay me directly. At what we tell them, you have to have the Mexican guild's permission so I can pay you. So there are no liabilities for me. If you get that permission, I can pay you directly, and that's not an issue because they may try to uh, uh, circumvent coming through their guild, and we tell them, well, we have our local guild and there has to be a sense of reciprocity and you will get whatever percentage you're entitled to. It's been only a few cases, but this is something we cannot really risk, and by law we have to abide by this. So we have to have an open relationship and a trust relationship so we can pick up the phone whenever we need their help. Edu, go ahead, please, Eduardo. Hello, congratulations to all the speakers. I know all of you, and these were great presentations. Now, allow me to ask you something. This is focused on. This goes to in-houses. Given that the entertainment business is very dynamic, it's always gone through changes and it moves really fast. I would like to ask you. So you've talked about the risks, and you've talked about how sometimes decisions have to be made. At the end of the day, this is a business, and the industry decides based on the business. So the question is, do are companies aware of the fact that you have to take on bigger risks? So when they ask us attorneys, how do they see us? What kind of role do we play? Are we negotiators, commercial partners, legal counsel, business enablers? I mean, what do they expect from us? Thank you very much for your question, sir. I think I'll take this one first, and it's we can go off here debating this, so I'll try to keep it brief. Companies know about the risk. Let me just give you an example. For those of you who know a little bit about the Japanese culture and music, the Ghibli and Yokisaishi composes a lot of the music for these songs, for these movies. So, and we went for a Yokisashi a candlelight tribute instead of going through the agency. So in order to do this, you talk to the publisher. The publisher was upset, and they're based in Japan. A lot of people were doing Yogi Saishi music. With that synergy, we were able to negotiate it properly, but we took on the risk because we had already put together 10 test concerts. This was consensual risk, saying, hey, if they catch us, they can sue us, and this can be a big, big lawsuit, not only on Yohei Saishi part of it, but the Ghibli studio as well. These are soundtracks from the movie that usually have shared rights. What happened to Yohei Saishi after he was very upset and he put out a publication saying that he was upset that a lot of people were using his music without telling him. We were able to approach him, talk about it, come to terms. We made good business, and in 3 years, this is one of the top 10 programs that we are selling, the candlelight concerts. And to answer your other question, I think that in those cases where the attorney gives you that assurance saying, hey, if there is a lawsuit and if we have to go to court, go to trial, instead of just sending you a cease and desist letter, if you send that to the people who are doing the business, they will appreciate it because you're saying, hey, there's risk here, but how possible is it a risk? And then you turn into a business partner. Being counsel, you're a business partner as you manage risk so they can make a decision. Gerardo says, I think this is a good question because based on my experience, there are usually two legal sides that may not overlap and should overlap. Sometimes it's okay that they do not overlap, but they have to be like this famous phrase, disagree and commit. There's always a party that makes a decision. It's usually the company owning the rights. Let me just give you a case, a very practical case. When it comes to content, AV content, production companies are usually responsible for doing the clearance. Platforms in a lot of the cases, platforms get the finished product from the production company and then they make it available to the public on the streaming platform or wherever. The production company's attorney is the in-house. He's a jack of all trades. He takes a look at admin issues, tax issues, any kind of issues for the production company. So for production companies as they grow, it is easier for them to have entertainment law counsel, but they usually do not have it. And when these people deal with streaming platform attorneys and TV company attorneys, you have some issues because the attorney advising a streaming platform and the one advising the production company, well, one is very conservative, the other one is very flexible. So depending on your angle is where the answer lies, but I think that as time goes on, we've been able to see, especially people in this forum, uh, the attorney is more practical. They take on risk together with the company, and I think this is something companies are very appreciative of. Martin. Thank you very much, and congratulations to the three of you, and obviously the moderator who's been leading this panel very well. So, two questions. In this very dynamic process that you're going through, and where there's a lot of negotiation, but how much of a strategy do you use or not? Um, Controversy resolution, mediation, arbitration, or do you go to court right away? That's one. And then maybe the next question, maybe you've seen this, or maybe in Mexico, cultural heritage, um, kind of material heritage, depending on where the concert is going to be. Do you deal with that? Well, in my case, with most of the contracts, we will, the artist or the agency, we deal with about, we, we 50% of artists are foreigners, so they will not accept Mexican legislation, nor will they want to go through Mexican courts, and more so now after the reform we are going through. So our day to day is, you know, coming to a middle ground. We use whatever applicable legislation exists, either California law, New York law, and then arbitration, sometimes ICC or JAMS. These are the ones that are most popular. A three member arbitration panel or a three-party arbitration panel, as balanced as possible, in English, of course. We haven't had to deal with too many K-pop bands, at least not now. There was this one case where they proposed that the arbitration be using Singaporean laws, but instead of the arbitration happen in New York, and there was a bunch of things that were pretty complicated, so we said, let us look for a middle ground, U.S., right? But it'd be impossible to have them accept local jurisdiction and Mexican legislation, so we're used to that. And the reality is that seldomly have we sued an artist directly. And if the relationship goes on many years back, we do not want to get blacklisted. Obviously, whatever is in the contract is honored so we can negotiate something that's a little bit more reasonable. We understand what the costs are. So we do try to always have the right support for it, and that it's all written into the contract and come to an agreement that is reasonable.
On my side, as I mentioned at the beginning, I believe my company being so young and starting like a startup, we had that startup mentality that, well, this has to happen yesterday, and if it happened yesterday, we didn't have a contract, and when you start executing a contract, you lose all the negotiation leverage. So as a general rule and culture, we always want to have an arbitration clause that is strong, a good dispute settlement mechanism. But the reality is, in this point, like I said before, I would love to be her competitor. I'm still not. We're still far away from being there to have a good internal system for communications where the contract is the first thing that you start checking before executing. But just answering the question, I believe that we also have a very strong culture trying to establish very clear rules for dispute settlement. Furthermore, trying to include in the contract what possible controversies may arise and what would be the adequate resolution mechanism, what are the communication channels, what are the notification terms, if there could be a prior mediation before we can get to arbitration as well. That would be the ideal, but it's hard to enforce. Martin, the material heritage is pending, but we have a question that was there before yours, so let's go. Thank you. I believe, well, I'm Jose Luis Barsadia from Ecuador. Being in an intellectual property forum, I cannot afford the luxury of leaving a cloud of doubt hanging over the collective rights negotiation corporations. I think they've been mistreated today with not very kind terms. But let's not forget something. The collective rights negotiation societies are as loud as when the lawyers send a cease and desist letter. I think it's important to take into account those collective management corporations are working defending their rights. In my case, for example, my practice, either the labels or the AV producers, I think we also acknowledge them. They're very misunderstood, but let's remember one of the historical cases that dates back from the man in white, known as Mark Twain. He was an enemy of intellectual property until he became famous, and then he became its staunchest defender. So I invite you to look into and understand these organizations that are part of PI and are also upholding the rights. I just wanted to clarify that. Thank you very much. Well, the thing, what happens is that each question didn't leave us enough time to give respect of the three. But when we were downloading this questionnaire, we had a debate, an internal debate as well, and my experience. And I think generalizing here is very difficult. You cannot generalize in my experience. I've had projects that have been very pleasant, very satisfactory with collective management corporations in Mexico, Argentina, and Europe. So I believe that yes, if that's the way you felt, perhaps it was because of one or two specifics, but you cannot generalize. For example, SAC in Mexico facilitates a lot of the processes. They have a tremendous repertoire of authors and composers. And then Deyanirr said a while ago that if a third party comes to file a claim, well, the window is the collective management, and in the contract you have clearance that any against to protect anybody from this collective negotiation corporation. Thank you for your questions. I would like to thank the panel speakers that were top notch and a beautiful closing for the sessions. And personally, thank you to each one of you. Thank you, Soledad. Thank you.